name is Deanne McLemore, and I represent the appellees Shondra Tucker and Linda Tucker in this action. We ask that the court affirm the final order of dismissal in this matter. Doss's 5 challenges to the trial court's dismissal really boil down to 2 main issues. One, he believes his due process rights were violated throughout this underlying litigation because of various instances that he alleges of judicial bias and other injustices, as well as he believes that the subsequent release, this letter of release as he calls it, was a counteroffer to the mediation settlement agreement that was made between the parties, and therefore no enforceable settlement exists, along with some waiver and preservation issues. The record and the law just do not support his arguments for reversal. First, it's made abundantly clear by the record, Mr. Doss was afforded every proper measure of judicial process in this action. Throughout the entire course of this litigation, Judge Peacock treated him with fairness and respect. He never was precluded from filing any documents, making any motions, responses, filing any evidence. He was given the opportunity to depose everybody he sought to depose, my clients and Dr. Shim, although he chose not to depose Dr. Shim after being given the opportunity to do so. At every single hearing, he was given full and fair opportunity to make his arguments and rebuttal to my clients' arguments. There were limited instances where Judge Peacock did have to control her courtroom, but in every instance, she acted fairly and reasonably in controlling her courtroom. All parties here were afforded due process. All her actions and rulings were reasonable, legally and factually supported, and well within her discretion. The second is that Mr. Doss did settle this case at mediation. He willingly and voluntarily entered into a mediation settlement agreement, and he doesn't contest that here. That agreement expressly incorporated release terms, including a listing of the exact parties and persons that he's now taking issue with. That agreement also had a term for a separately executed general release, that second subsequent release.
But is it your position that the letter of release is effectively superfluous given the language of the stipulation?
The letter of release or subsequent relief is not superfluous. It is just a term, an enforceable term of the mediation settlement agreement. It's the mediation settlement agreement that is actually the settlement contract here. It lists out different release terms or enforceable terms, including my clients would pay the $30,000. They would satisfy, State Farm would satisfy Mr. Doss's VA lien against him, as well as a separately executable general release and indemnification agreement. All parties agree to be bound by those terms.